Let me start off by saying when I started practicing law 41 years ago, things were a lot different. Not only were they a lot simpler, lawyers generally regarded one another as friends and brethren and brothers, because there weren't many sisters at that time of the bar. And if you had a question, you might call your opposing counsel and they'd give you an answer, and it would be the right answer. If you filed a stupid pleading, which I used to do and probably still do on a regular basis, somebody would call and say, do you know that in paragraph 16 of the answer, you admitted liability as opposed to denied it? And I would say, oh my gosh, and make the change, where now something probably different would happen. They would all start dancing around the office and said, line screwed up again. We're going to pop him and let his malpractice premium go up again. Lawyers have grown more and more uncivil, and what I hope to do today is to go through some of the reasons that I think it's happened, some of the things that I think we need to do in order to get back to where we're a profession instead of a mere business. A lot of this came out of the development of what was called hardball litigation. And litigators would fight and carry on and with their opponent lawyers, and not only would this serve to harm them in the profession, it would run up bills for clients. It would cause the reputation of lawyers to hit the just absolute toilet. Reminds me of a story of a litigation lawyer, very, very prominent litigation lawyer, that his firm, after he had just caused wreaked all kind of havoc in the office by throwing things at people and cussing people and losing clients, and so they sent him on a cruise with his wife of about 25 years, I think probably his 8th or 9th wife, and hopes that he would maybe learn to relax a little, and a wonderful lawyer, but just horrible temper. So they were out cruising, and he was up early one morning and wandering, and they'd been out 4 or 5 days, and he was just kind of contemplating the rising sun and looking, and all of a sudden, he saw something, and he leaned over, and he fell overboard. His wife, who was just coming up to find out what he'd doing, saw him fall. And she ran up and looked over and just was screaming and carrying on, and that attracted the attendants, and they came out, and the captain came out, and they were looking, and here was this guy flailing out in the water. All of the other passengers came out, and this guy was carrying on and screaming and cussing, and as you might imagine, scared to death. And they were trying to figure out what to do. Then they looked up, and here started coming up a school of sharks. And the wife just shaking her head and saying, oh my gosh. The captain asked what religion the guy was, and she said back when he had religion, he was Catholic. So they found a priest, and the priest rushed up, and he said, well, I think I probably need to give the man last rites. So about the time he started, here's all this turmoil out there. The sharks, I guess sharks like everybody else have a leader. The leader swam up and approached the lawyer, and they thought it was over. But he turned around, assume it was a he, put the lawyer on his or her tail, flipped him back on the ship. The chaplain, the priest raised his hands and said, oh my Lord, it's a miracle. The wife said, no, Father, simply professional courtesy. As I said, when I started practicing law, lawyers were more civil. This topic is becoming more and more common, not only in seminars but also articles. As a matter of fact, this paper is going to be published in February or March in the Practical Lawyer. So hopefully it'll get some more publicity. But let me get into the reasons that I think that our profession has slipped to the levels that it has. But before we get there, let me give you an example of a situation that I believe anyone who concludes that this is not a wonderful example of incivility by lawyers, I don't know whether you need to stay after class or leave, because this is the epitome of what happens in depositions. And those of you who aren't litigators may say this doesn't happen. I guarantee you that I have seen worse in depositions take place. This is a famous clip, and I'm sure all of you have heard of the lawyer Joe Jamel from Houston, who got the $umpteen billion judgment against Texaco on behalf of Pennzoil. He was, and still remains a hardball litigator. He got that reputation well-deserved and well-earned. But just take a look at this.
Did you talk to this man sitting next to you before this deposition started?
Yesterday, but he had nothing to do
I
with
didn't
what
ask
you
you
are
that.
currently saying. I said it, though, didn't I?
Did you talk to him, sir? What did you say?
I said nothing. I said, you have a case of incipient verbal diarrhea.
Oh, sir, we're going to see about that.
Not good.
Did you talk to him yesterday?
Yes.
How long?
About 3 hours.
Talk about this case?
Yes.
Did you tell him the other companies you consulted for?
No. I did
You're
not.
under oath here.
I did not.
We'll see about it. When you were at Monsanto, what was your title?
At Monsanto, what do you mean?
In Texas City.
Research chemist.
And was that your title during your entire stay at Texas City?
Texas City, yes.
Don't talk over each other.
After you left Texas City.
Wait a minute, let me ask a question here.
Yeah.
You represent this guy or not?
Who are you?
My name's Tucker, and I represent Ayrshire, and I just want to know, do you represent the guy or not? I'm getting, if you don't represent him, you don't have any right to be making any objection. If you do represent him, tell us so.
Why don't you keep your mouth shut? I'll do what I want.
No, you're not
Hold
going to do
it.
what you want.
Oh, wait.
I'll do what I want.
No, you're not.
No, you're not.
Yeah, I am.
That's
I'm gonna make
bullshit.
whatever objections I want to make, and I'll make them as loud as I want to make them. Or you just shut your mouth and we'll keep the record straight.
Don't tell me to shut my mouth, boy. You may be big, but you want to see how bad you are? Come on.
And I wouldn't try that, Ed.
Are you threatening to fight?
Hold on just a second.
Oh, I want to know whose side we're on. We're going to be outnumbered, Ed.
Hold on just a second.
No, you got a big mouth. Now, you do. You need to either represent the man or not.
I'm
I've tolerated
representing Monsanto, and I'm
But
making
you're
an
not-
objection on the record.
Then you're not entitled to be his lawyer then, okay?
I'm not representing the man.
Well,
I'm
you're
making
trying
an
to be.
objection on the
And
record.
another thing,
Don't tell
you
me
don't.
what I'm trying to do.
Yeah, I'm going to tell you something else. You don't run this deposition. You
Neither
understand?
do you, Joe.
You watch
Neither
and
does
see.
he.
You watch and see who does, big boy.
I'm telling you, Joe.
Oh, you ain't telling me a goddamn
I'm gonna make
thing.
whatever objections I want.
You
to
can make your objections and
You can talk
then
as
keep
loud
quiet.
as you
See,
want. No,
but
I'm
don't be
not.
telling another lawyer to shut up.
Don't be
That
telling
ain't
me
your
to shut
goddamn
up.
job,
No, that's not
fat
your
boy.
job. Mr.
Now get back-
Keys.
Now you got
As
time
I
to
said
answer
before,
me?
you have an
Hold on just a
incipient
second.
bad
What do you
mouth,
want to
don't
do about it, asshole?
Oh, I'd like to knock you on your ass.
Come
I'm
try
not
it.
gonna do that.
Come over here and try it, you
Wait a minute.
dumb son of a bitch.
Wait just a second.
Come over here.
Hold it. Hey, wait a minute. Hold on.
close.
No way.
Get close.
Hold on just a second.
Associate are taking Mr. Garrett out in the hall to lecture him, I suppose. They're doing this over our objection. We started this deposition, unable to get an answer from this man.
Anybody see the incivility there? Let's get to what I call the 20 reasons, 20 of many reasons why I think we have lost the charm of civility of our profession. The first is we have turned out way too many lawyers of the law schools. When I graduated from law school in '67, it was an absolute growth industry. They could not get enough lawyers turned out of schools. Every area of the law was booming. Environmental law was just coming into its own. Labor and employment law was absolutely just booming. Personal litigation was just growing. It was becoming a national pastime. But not only did we turn out too many lawyers, when you turn out too many of anything, a lot of them get through the training without picking up the real professionalism behind what we are. That's true of doctors, it'd be true of lawyers, be true of preachers, be true of nurses, whatever. If you rush to turn out too many, you're going to turn out some, and maybe more than a mere some, that aren't going to understand how or why lawyers and other professions, why they're called professions. When I got out of school, I made $5,000 a year. With a bonus, I made $6,000 a year. That was less than 40% when you looked at my workload of the current minimum wage, and that's before it was recently raised. But at the same time, I could borrow 3, 4, 5 times as much as my salary on my signature simply because I was a lawyer. Because I was a lawyer meant something. People assumed that I was going to be or was somebody. Now they say, there goes another lawyer. They come up with a joke, and we've got lawyers running out our ears. Second reason. Lawyers used to be the ones who not necessarily made the decisions, but developed the strategy for how, whether it was litigation, a transaction, a procedure, a particular business deal was going to go down. And if the lawyers said that isn't going to work or that isn't the right way to do it, my experience was the client said, okay, is there another way to do it? And if there weren't, the client said, well, I guess we can't do that. In an effort to fight the growing demand to be able to fuel your bottom line or the lawyer's bottom lines, lawyers have been willing to not only maybe try to help the clients do something they want to do, whether they, quote, should or shouldn't based on the lawyer's professional judgment, but the lawyers also, on occasion, have been complicit in the scheme to devise a plan to do something which was, if not patently legal, was patently wrong. There are probably more lawyers in jail in the last 8 or 9 years than there were going back to whenever lawyers commenced to be. Because lawyers got wrapped up in their clients' problems, from my opinion, primarily because they did not have the professional guts to say no to clients. If a client said, for example, let's serve 913,000 interrogatories on this poor plaintiff, and we will wear him or her down with paper so that we can prevent that person from obtaining justice. That isn't exactly how they said it, but it was pretty darn close. I used to be a class action litigator and sometimes we would get so wrapped up in what we were doing that we forgot that our judicial system was aimed to provide justice. Now, it was not always the defendant's fault. Plaintiffs' lawyers have done their share to cause the same kinds of problems by filing all sorts of strike lawsuits, blackmail lawsuits, whether it's for copyright infringement or whether it's every time a major corporation is bought out, sold, merged, whatever. There's a line of lawyers from here to Pittsburgh wanting to file lawsuits in order to get in on a big paycheck. That ain't why we were trained as lawyers, and that's not our job. But it starts with the lawyer being the captain of the ship and advising the client and sometimes saying no. Even though you know, if you say no, there's a lawyer down the street that's going to say yes. It's easy to say and hard to do. That's what you need to do, but if we don't, we're going to kill the goose. This exemplifies also the clip that the Joe Jamal deposition, that it's our clients that are fighting, not us. Most of y'all probably remember from law school hearing stories about lawyers fighting like cats and dogs all day long, and then after the day in court or the day in negotiations or whatever, they go out and have a drink together. Some of my best friends as lawyers are those that I have fought with, gotten at each other's throat during litigation and negotiations, but hopefully we never forgot that we were there carrying water for someone else. That when it was over, no matter who won or lost, we were going to be there and our relationship was going to continue. Those of you who have heard about my vast reputation as a litigation lawyer may find it hard to believe that I have gotten my rear end stomped numerous times in court by lawyers that I had the opportunity to return the favor later. What you're supposed to do in those situations is to congratulate the other side and say, good job, John, good job, Mary. I'm not surprised you did such a good job. And the reason for this is that even if we as the lawyers are the captains of the ship, we don't create the facts. If I were able to create the factual patterns, there's no way that I would ever lose a litigation matter, a negotiation matter, a business transaction. But that's not the way it works. What our job is to take what is presented to us in a transaction. If you're negotiating a record deal and you're representing the artist, unless your artist is way at the top, you understand the golden rule. And I assume all of you know what the golden rule is in entertainment business. He or she who has the goal makes the rules. What you try to do is to take a sow's ear and make it look as much like a silk purse as you can. That's what lawyers are supposed to do. And you do this by creating, not by fighting. And if you ever forget that it's the clients that are fighting and not the lawyers, you will not have a good reputation with clients. But more importantly, you won't have a good reputation, particularly if you're in litigation, with the judge. There's a lawyer that I dealt with for years. I'll call him Smith. Y'all wouldn't know him anyway, but I'll call him Smith. in federal court in Arkansas, in Little Rock, the judges had a phrase that they use, well, that's a Smith plea, because it was pure BS. He would file 19 motions to dismiss in a case of clear liability, simply in order to clutter up the record. Once you get a reputation with the judge or with any other fact finder as non-professional, you're going to lose a lot of cases that you should win, because most matters that go to trial are close. And if it's a judge or a jury, they're going to have to exercise discretion on some areas, particularly in the judges, when you've got motions for summary judgment one way or another. And if you are a Smith, you're going to find that you're going to lose not most, but all of the close cases. That is not being professional. That's not representing your client well, in my opinion. This ties in that we have forgotten that we're hired to be objective and not gladiators. My pictures are gone. Pictures were neat. The reason people come to lawyers is to get objective advice. If you are unwilling to think and provide objective advice, you are not going to be serving the purpose that clients come to lawyers for to begin with. The two parties can get together and act like gladiators because they sincerely believe that whatever position they're taking is right. Your job is to maybe convince your client that maybe there's some gray on the board. It's not all black and white. And you will find that clients long term will respect you because after it's over, they will learn and appreciate it. You got them 90%, 80%, whatever percent of what they wanted. And you saved them not only a lot of money, a lot of time, a lot of grief, and maybe a lot of embarrassment. We have fallen into a trap that the only thing that's important is to win. Win at any cost. Someone makes an honest mistake. You discover something that you need to disclose. You don't disclose it. And it becomes more important to win than it is to promote justice. To its logical extreme, this includes tampering with evidence. I was involved in a case once with one of the lawyers in my, used to say my prior firm, it's now my double prior firm, where it was an employment case, and we discovered that one of our lawyers would take documents in personnel files, and what he called it was clarifying it. I don't know how many of you are familiar with employment litigation, but a lot of times the documents in a personnel file, if you're the employer, will literally hang you. But if years after the fact a memorandum can be, quote, clarified as to what happened in a particular situation, makes a very powerful exhibit. It's just dead wrong, dead wrong. You ought to be disbarred for it. You ought to be disbarred for that. There was another case involving the same lawyer who's now off somewhere else, removed things out of an affirmative action program which looked horrible. The term was, they were talking about the reason that there were no women on a particular line of a manufacturing facility. And the justification given in the affirmative action program was that the women preferred to be on this other line because they had time to have discussions and work on their recipes while they were working. So that was the justification for more women over here than over here. Well, that was taken out of the affirmative action program that was submitted to the other side in discovery. Well, guess what? The other side had a copy of the real one, where something even as crazy as that sounds could have been explained. There was no explaining to the judge when it was not provided in the document. So the lawyer said, it's more important for me to win this case on behalf of my client now than it was to be respectful of the evidence. It's one thing, the message that sends to lawyers. What kind of message does that send to clients? I have a lawyer who is willing to lie, cheat, and steal on my behalf. I submit that might look good at the beginning, but after a while, that client's going to think, if that guy will do that, what will he do to a bill? What will she do to something that's going to hurt me instead of help me? Not even mentioning the fact that they killed the client by doing it. If several of these seem to be kind of running together, they do, because it's all part of one big ball of string. We have focused more on quick advice instead of reflected and considered advice. Fixed it with duct tape. I don't know if people up north know about duct tape or not, but duct tape is a universal fixer in the South. One of the biggest differences I have found in my law practice now from where it was when I started is the amount of time that I have to think. I don't have much time to think. I have to make quick decisions now. Clients want decisions right now, right now, right now. They'll tell you on the front end they don't care if it's right or wrong, they just want an answer. After the fact, they'll say, what do you mean you told me that and you weren't sure it's right? Sometimes you have to tell the client to slow down. I have to think about that. If your client doesn't trust you to give you enough time to give them a reflective answer, then I submit that you're better off without that client. This follows up on that. When you're giving a client some advice on doing something, you need to think, and we need to think, as to what the long-term impact is of this particular advice we're giving them. It might be right now, but it's wrong long-term. We may win in the short run and lose in the long run, not we, but the client. You do that a couple of times for a client, you'll have a client for a long time. We have forgotten that we're involved in a profession, not an ordinary business. We display our plumber's crack on a regular basis. All of you have heard the story about the plumber and the lawyer. The lawyer hired the plumber to come out to work on the drain. The plumber came out, worked on it, and fixed it. Was there about 30 minutes and said, that's $100. I said, whoa. I said, that's $200 an hour. I said, I'm a lawyer. I don't charge that much. The guy said, when I was practicing, I couldn't get that much either. We've allowed ourselves to become slaves to the time clock and billable hours. Very hot topic now in law schools coming out. Big law firms requiring the young lawyers to have 80, 90, 100, whatever number of chargeable hours a week. If you're paying them $150,000 to start when they don't know squat, it's understandable. You've got to get that in order to get your return, and you judge people by how many chargeable hours they get. A lawyer with a number 2 pencil can create a lot of hours. But churning files and creating chargeable hours certainly does not lend a view that we're a profession and not a bunch of just ordinary workers. This point deals with how we treat our adversaries in litigation and transactions. We need to remember, I'll see this person again. I can tell you people that are on my list that have done things to me. And even as old as I am and as feeble as is my mind, I can remember those people, and if you ask me, I can rattle them off. That they did something that I found highly unprofessional and underhanded. I'm sure people think I have done the same thing, and if anyone tells me, I think you did this, I go back to my AA training and I say, if I was wrong, I apologize. An apology can solve a lot of problems. Trying to be sharp can create a lot of problems, not only for you, but also for clients. Along the same line, if I tell a lawyer I'm going to do something, if I tell a client I'm going to do something, if I tell my spouse I'm going to do something, I need to recognize that my word is my bond, I'm going to do it. I'm not always successful. If I tell a client I'm going to have them something by Tuesday, I may have to call him and say, you didn't ask me which Tuesday. But they understand that. But if you have a general reputation for saying one thing and doing another, it'll come back to bite you in the behind. Common courtesy, much better than sticking down. All of you've seen the book, Everything I Need to Know I've Learned in Kindergarten. Lots and lots of truth to that. Treat people politely, and it will pay dividends. Treat clients politely. We're not gladiators. We're professional people that are supposed to be delivering sobering advice. Try to act like a professional. This gets into why you do a lot of things. We've forgotten that we engage in our chosen profession to live life well, not to live to practice law. There are other things in the practice of law. Every time I say this, Bruce looks at me and says, boy, believe what he says, not what he does. Because I sometimes get so wrapped up in what I do, I forget. An addiction to the practice of law can kill families and kids and relationships as quick as crack and alcohol and heroin can. This also ties into reflective advice. What I like to do is when someone presents me with a very interesting and difficult question is to take a deep breath and to think and try to give them a reflective answer. And if they say they want an answer right now, what I want to say and what I should say is, let me give you a number of a lawyer to give you a quick answer. Maybe wrong. I'm not even I who have the guts and the sanctimony to do that, but that's, I've got a rule that when I get so uptight and I can't get good advice and I can't deal with what I'm doing, I get up and walk out. I learned that in treatment. It teaches me several things. One, it gives me a chance to think, but more importantly, it teaches me that I'm not indispensable. Take a deep breath before reacting or talking and giving a position. You know, There's an old saying, God gave us 2 ears, 2 eyes, 1 mouth. So we ought to do twice as much listening, twice as much looking, and half as much talking, maybe a quarter as much talking. This deals with how we achieve that as we try to get some kind of balance in our life. We have something to do other than practice law. It may be shooting pool, it may be shooting craps, it may be playing tennis, it may be swimming, it may be whatever, it may be reading books, listening to music. But you're going to give better advice if you back off and have some balance in your life. This is another AA remedy or saying, halt. Don't get too hungry, angry, lonely, or tired. Because if you do, if you burn the candle at both ends, you can't give good advice. We've done that. We do that in order to achieve this god-awful number of chargeable hours we need to get in order to survive, in order to make enough money to pay for the 3rd Porsche that we bought, or the 4th wife that we divorced, or husband that we divorced.